كما تعلمون حضراتكم ينظر في مجال التحكيم الدولي ألا تشمل المطالبات طلباً بالتعويض سواء من أحد الأطراف أو الطرفين أو من كليهما. وإذا كانت هيئات التحكيم لها سلطة تقديرية واسعة في تقدير التعويض، إلا أن هذا يفترض بداهة قدرة هيئة التحكيم على استيعاب طبيعة الأضرار، سواء الأضرار المادية أو المعنوية، عناصر التعويض من خسارة وكسب فائد. فالواقع العملي بيكشف خصوصاً في التحكيمات الدولية عن صعوبات يواجهها ليس فقط الأطراف ولكن بطبيعة الحال هيئات التحكيم في سبيل تقدير التعويض. الأمر بيقتضي في أحيان كثيرة أن يبادر الأطراف بتعيين خبراء فنيين لتأييد دعواهم فيما يتعلق بالتعويض، وقد يقتضي الأمر أيضاً أن تلجأ هيئة التحكيم إلى الخبرة الفنية. في هذا الإطار هذه الجلسة سوف تتناول 4 موضوعات. الموضوع الأول يتعلق بأفضل الممارسات المتعلقة بالدليل المستمد من الخبرة في مجال تقدير التعويضات، وسوف تتناول هذا الموضوع الأستاذة صوفي لام، الشريك والرئيس المشارك للتحكيم الدولي بمكتب ليثم أند واتكنز، ولها خبرة وباع طويل في هذا الأمر. الموضوع الثاني يتعلق بمدى تأثر إجراءات التحكيم بتقدير التعويض وأفضل السبل الإجرائية في مسألة الإجراءات وتقدير التعويض. وسوف يتناول هذا الموضوع الأستاذ كريغ مايلز، شريك بقسم التحكيم والمنازعات القضائية بمكتب كينج أند سبولدينغ. ثم نأتي إلى موضوع متخصص وهو تقدير التعويض والأبعاد المتعددة للتعويضات في مجال منازعات الإنشاءات أو منازعات التشييد، وسوف يتصدى لهذا الموضوع الدكتور المهندس نبيل عباس، المحكم ورئيس مكتب نبيل عباس للاستشارات الهندسية. ثم نختتم بموضوع الأخير وهو مسألة تطبيق ما يطلق عليه التعويضات العقابية Punitive Damages باللغة الإنجليزية في مجال التحكيم. وسوف يتناول هذا الموضوع الأستاذ بيون جيل، المحكم المستقل وعضو وشريك بمكتب نيوتن للتحكيم الدولي. اتفقت مع زملائي أن نستغل 1.5 ساعة مع حضراتكم بأن يخصص لكل متحدث 15 دقيقة، يلي هذه الساعة 30 دقيقة للمناقشة مع حضراتكم. وإن سمح الوقت ممكن أدعو بعض المتحدثين أن يعرضوا على حضراتكم بعض الملاحظات الختامية، ونبدأ فوراً. وأدعو الأستاذة صوفي لام للتفضل بإلقاء كلمتها.
Good morning, everyone. Thank you very much for including me in this wonderful conference. It's a pleasure to be back in Riyadh, an honor to be amongst you. So I've been asked to say a few words this morning about the role of experts in the process of quantifying damages and presenting damages, theories and evidence in international commercial cases. So I'm going to talk a bit about best practices that have emerged in the area, some of the norms of practice that we are seeing. perhaps I can just preface my presentation with a few observations, and those are that the practice of using party-appointed experts really is now commonplace. I would go so far as to say that there is both an expectation and a norm that in complex cases, parties would indeed look to independent experts to support, to validate, to authenticate and explain their theories of damages. Secondly, that it's certainly true that the disputes submitted to arbitration, particularly over the last 5 years, have become even more complex than before. And really, we are measuring these cases in the hundreds of millions of dollars, if not billions of dollars, often projecting lost profit theories out for a decade or more, or indeed quantifying entire businesses that are themselves predicated on many moving pieces and many assumptions as to how the future will unfold. And because of that, international tribunals have had to, and indeed have become, far more numerically versant. They are very familiar with many of the complex models that are used to support damages theories. And so too, us lawyers have had to become, and have become, more numerate and more versed in the finer details of these models. So really what we've seen is a collaboration between the counsel team, the in-house counsel team, and a variety of experts working together to produce a report and a model, the purpose of which, and I put this for your attention on the slide, the purpose of which is to assist the tribunal to decide the issues in respect of which the expert evidence is adduced. And the reason that I reinforce this is that although the expert has been working, if you will, as part of the team of a party, it is very much the ambition that the tribunal will be, that the expert will be and remain independent, and that they will see that their primary duty is to assist the tribunal and not to be an advocate for any particular party. And this is really sort of crystallized in these key concepts of independence and impartiality. They apply, of course, to tribunal members. We know and we understand that. That's what gives credibility and trust to the process, but so too for the role of experts. And as much as it is a collaboration with a wider team, and experts work very closely with external counsel, ultimately the expert's report must reflect his or her own independent opinion, not influenced by the parties. Now, while there are no fixed rules which govern as such the duty of the expert, the relationship between the expert and the tribunal, certain best practices have emerged, and those are recorded in international standards such as the IBA, that's the International Bar Association rules on the taking of evidence. These standards are very much a product of collaboration between lawyers from all over the world. They reflect, and they are intended to reflect, expectations and practices across a number of legal systems. They are not solely derived from the common law, from the US style of practice, from the style of practice in the United Kingdom. They are intended to reflect international practice. And some of these standards indeed do speak to the role of experts, and all of them reinforce the importance of independence and impartiality. So whether to engage a quantum expert, I mean, my assumption for today's conference is that the sorts of disputes that you will be dealing with, that we on the panel are dealing with, are of such an order of magnitude and complexity that it will typically always be appropriate for there to be an expert. It would be fair to say that it's particularly important in loss of profits cases where, by definition, much of the case is built on assumptions as to what will happen in the future. And those could be assumptions as to how certain markets will move. Those could be energy markets, they could be foreign currency markets, They could be supply-demand dynamics, they could be trade flows and trade patterns. All of these are the subject, or an appropriate subject, for expert evidence. And indeed, so far as a quantum expert is concerned, it may draw together a number of strands of expert evidence. So the expert, the quantum or the testifying expert, may be working in tandem with a group of other experts, but ultimately putting forth his or her own opinion. So working together, as I said, in collaboration, thinking about what one's opposing party is likely to do, and then considering when is the appropriate time to engage an expert. And my strong advice would be that an expert should be engaged as early as possible. While we typically start to think about damages in terms of our presentation of a case towards the end of that presentation, in fact, the damages theory can impact on which arguments we choose to raise as lawyers, how we structure our factual evidence, what other factual or indeed expert witnesses we need to bring to bear in order to support that damages model, and therefore engaging with a damages expert as early in the process as possible typically is extremely valuable. And the role of the expert is not only to present a method, a methodology, and a report to the tribunal, but the expert can also play a very valuable role consulting with the legal team on how to direct some of their submissions and their fact-finding, and indeed engaging more generally with in-house representatives, perhaps with a board, and certainly with external counsel, to set some reasonable expectations as to what a damages outcome may look like. And that, of course, can be a particularly useful exercise when one is thinking about trying to resolve the case early, whether that's through a negotiation, through a mediation, or some other method that doesn't, in the end, require a full arbitration. So appointing the right expert, fundamentally, this is a question of expertise. As I've mentioned, often in complex cases, a number of bodies of expertise may come together. Ultimately, though, we are looking for somebody who has some experience in testifying before tribunals. Typically, as I'll come on to explain, it's not only the case that an expert needs to produce a written paper, a written model explaining that methodology, but also will need to be ready for questions from the tribunal and significantly from questions from the opposing party, what we refer to as cross-examination. So a key area for due diligence on the part of the in-house and the external team is on expertise and experience. We're really looking to make sure there is a robust set of credentials supporting this particular expert's view of damages, particularly if they are looking, I would suggest, if they are looking to create models that project out into the future. The expert's credibility for doing so really rests and falls with work that they have done, perhaps industry experience that they have had, and so on. Ultimately, of course, this is a task of persuasion. We are looking for somebody who is going to persuade the tribunal that this is the right way to think about damages, and that the numbers that have been presented, the assumptions that have been used are both reasonable and credible. So the ability for the expert to be able to present often a very complicated data set in simple terms, in persuasive terms, to be able to speak, if you will, in layman's language is a key facet, a key skill set for any good expert. So we'll be looking to see that our expert, our chosen expert, has experience in hearings. We're looking, of course, to see that they are available to engage with us over the relevant time period. And I've just made a note at the end that, of course, it's the case that sometimes tribunals appoint their own experts, but typically in the sorts of cases that we see, the very high value disputes, it's parties appointing their own experts. So instructing the expert, this can be done either by legal counsel defining the mission, the criteria, the assumptions, and so on. Sometimes the tribunal will give some input into this. I would say it's the rare case in which a tribunal at the early stage of a case is already so well integrated, if you will, with the facts and the assumptions that they're ready to set forth some sort of parameters as to where they see relevant legal issues and relevant quantum issues emerging. So typically, it is the task for counsel to set out those parameters. And what those parameters do really are to try and ensure that the expert is confining his or her report to the area in which they have relevant and provable expertise. We're trying to avoid the expert venturing into the realm of advocacy, of argument. What we really want is for the expert to be presenting and to be seen to be presenting an objectively verifiable and robust data set built on assumptions that are reasonable. Perhaps they're built in the past performance of a particular company or a particular industry, and they're projecting out to the future based, as I said, on reasonable assumptions as to how markets might move. Typically, we see two experts in any two reports from any expert in the legal proceedings. So they will provide their first report either with or shortly after the major submission from the party who has appointed them. But there will then be an opportunity for the expert to engage with their opposing expert, should there be one. And it's this second report that really tries to synthesize the scope of difference between the parties. The expert should be encouraged to move and to make concessions where it's appropriate to do so. And all of these exercises, this shifting, this dynamism in the process is very much something that gives and enhances credibility to the expert in the eyes of the tribunal. And there is a continuing dialogue with counsel throughout this process, and that's perfectly legitimate. And the reason for that, of course, is to make sure that as the facts develop throughout the lifetime of the case, as they often do through the process of disclosure, perhaps engaging with an alternative or rival theory that's been put forward by an opponent, it's important that the expert looks to incorporate some of that into his or her second report. It may be to reject it, but it will give, he or she will give credible reasons for that. But this process of constant engagement, of dynamism, is really key to the use of an expert and to having credible evidence before the tribunal. So there is no set model as such that any expert can use. It would be fair to say that in lost profits scenarios, it's the DCF model that most tribunals are familiar with. Whatever happens, the way in which the model is presented should endeavour to be somewhat dynamic, in that because tribunals have become very familiar with how these models work, the different inputs into, for example, a DCF analysis, they sometimes want to sort of play with and manipulate that model for themselves. So to give an example, a DCF model in which the opposing experts use vastly different discount rates, say 15% from respondent's expert, only 5% from claimant's expert. The tribunal, having heard the evidence, both factual and expert, may want to see that model and how it changes using different rates. It might ask the experts to do that, but similarly, it might wish to do that for itself. And that's actually quite a common practice that we see now. We see tribunals very much engaging in the experience of quantifying damages and getting themselves involved in those models. Very briefly then, just before the hearing, sometimes we see the opportunity for the two experts to come together. Tribunals are often very much in favour of this. Legal counsel less so, because it does risk what we see as us losing a little bit of control over the process. But ultimately, this is something that tribunals find very helpful. What they like to see is that the experts sitting together and without the influence of external counsel might look to try and narrow the ground between them, or even reach some agreement between them on certain key events, whether they be timing, certain estimates, appropriate discount rates, and so on, with a view to making the hearing itself more efficient, with a view to reaching sensible accommodations where those are available. So the sorts of things that they might talk about, as I said, are things like discount rates or certain key dates. It might also be used to narrow the range of differences between them, and possibly they might agree on a shared presentation tool which will demonstrate for the tribunal the key differences in their models. And again, from the tribunal's perspective, the key benefit of this, of course, is that we don't have what can be an exercise in ships passing in the night. So experts speaking to different issues, using different models, and the tribunal is left really in a very difficult position, possibly just choosing between one or the other, or worse still, finding its own way, which doesn't truly reflect either party's view of the case. So that sort of joint meeting before the hearing may result in something like a joint statement. And then we come to the hearing itself, and as I've explained, it's not just a written report that is typically required of the expert evidence, it's appearance at the hearing itself. And so often what we see at the beginning of the damages section of the hearing, which, as many of you will know, often comes towards the end of the hearing, is a short session where both experts themselves present their methodology directly to the tribunal. And often this is to demonstrate how the model itself works, to reinforce the key assumptions, perhaps to make some concessions or changes because of the way that the factual evidence has developed through the case. So typically we see a 30-minute or so presentation from both the experts, and then each in turn is turned over for cross-examination. And that's the opportunity for the opposing party to really test that case and to put their own case, to put different hypotheses to the expert, perhaps to make some points about lack of expertise in certain areas, sometimes even to point out mistakes. All of that is within reasonable bounds for any cross-examination. And indeed, the tribunal itself will very likely have its own questions on the model. So that is quite an involved exercise for any expert, and it's something that we do take time and attention over as the counsel team in our preparations. We work closely together both to prepare our own expert for that experience, but also to benefit from our experts' experience as we approach the task of cross-examining our opponent's expert and thinking about how best to attack or discredit the theory of damages that they have put forward. So we're working really in close collaboration with our experts from the very beginning of the case all the way up to and through the hearing. One variant on this process of presentation and cross-examination that I've mentioned is what has become termed as hot tubbing. What that really means simply is that the two experts are encouraged to sit together, physically together, as they give their evidence to the tribunal, and questions are asked to them as they sit together. The idea being that truly independent and impartial experts would feel a certain peer pressure, if you will, to answer candidly and to make appropriate concessions if their peer is sitting next to them. And often you see a process, quite a dynamic process of engagement and discussion between the experts as they really try and tease out what the key and what the real areas of difference are between them. Tribunals often find this really quite a helpful exercise. It can be a difficult one to control. It's not always external counsel's preference. We like to be able to control the cross-examination process in the main. But again, ultimately, what matters in all of these exercises is that the tribunal is persuaded as to where the damages outcome needs to arrive. And if this is something that the tribunal wants, then of course legal counsel will be well advised to listen to that. Now, the hearing itself is not always the end of the process. Sometimes, particularly in the complex cases, so many facts have emerged or changed, or issues narrowed, in fact, that by the time we get to the by the time we get to the end of the oral hearing, we have a very closed set of parameters, and sometimes the tribunal asks the experts to go back one last time and look again at their model, perhaps using a certain number of assumptions that the tribunal is thinking more closely reflect reality or are more reasonable in light of all the evidence that they have heard. So there might yet be one final opportunity for the experts to put their theory together. And then we await the award. So I hope that's been, well, if brief, a practical and helpful overview of how we engage with external experts in the course of an international commercial arbitration hearing. I'll turn over now to my colleagues, but of course very happy to answer your questions at the end of our presentations.
Thank you very much, Sophie. And I now immediately give the floor to Craig.
Thank you, Dr. Raouf, for that introduction. Thank you to the organizers for inviting me. It's an honor to be here. It's my first time in Saudi, and I must say the hospitality has been incredible. And thank you all for being here on the second day and listening to my presentation. My topic is the impact of quantum on the process, bifurcation or trifurcation. I imagine that most of the people in this room are familiar with the concepts of bifurcation and trifurcation, but for the avoidance of doubt, bifurcation is the process of separating a discrete issue for preliminary determination, usually, if not always, a determination that if made in a certain way would be dispositive of the case and avoid the need for any further stages in the arbitration. And you could bifurcate almost any issue, but the most common ways bifurcation is done in practice is either bifurcating jurisdiction first and then dealing with liability and quantum, or alternatively bifurcating quantum and deciding quantum only after jurisdiction and liability have been determined. Trifurcation is simply deciding jurisdiction first, and then if the tribunal finds jurisdiction, moving on to liability, and then if it finds liability, and only if it finds liability, getting to the quantum phase. Now, there could even be more than 3 phases. I have a case now that's in quantum phase, a separate quantum phase, but it's actually the 4th phase of the case because there were 2 separate liability decisions that preceded it. But for the rest of this discussion, I will use bifurcation to mean the process of separating the quantum determination from anything that came before it, no matter how many stages that may have been. Now, the traditional view on bifurcation or no bifurcation of quantum, in particular, in my experience, is that the claimants don't want it and the respondents do want it. And their arguments tend to be mirror images of each other. From the claimant's perspective, it takes longer, it's inevitably more costly, it's less efficient in the sense that if the claimant, who has to go into a case thinking it's going to win on all the issues anyway, it gains nothing by splitting it into phases other than extra time and cost. And claimants also tend to believe, as a matter of optics, and you hear this over and over again if you represent claimants in an arbitration, that they have to present their whole case at the beginning so that the arbitrators can understand all the damaging effects that the respondents' acts had on the claimants. And they fear that if they just discuss liability, that's too sterile of a discussion and it doesn't gin up the arbitrators' emotions in the claimant's favor, that they really need to see the whole case and all the impacts. And in fact, there are some jury studies in the United States that show that when jurors hear in the opening statement about damages and the effect of the claimants on the effect on the claimant of the respondent's acts, that the jurors have an immediate, more overall positive view of the claimant's case. Now, arbitrators are more sophisticated than jurors, but I think it's an interesting concept in terms of the psychology of persuasion. Now, the respondent, of course, they want to drag the case out as long as possible. If they could have 1, 2, 3, 4 phases, even better. They have 3 chances to win on a trifurcated case. They can win on jurisdiction, they can win on liability, they can win on damages. Even if they lose, they delay the process long enough so that by the time a quantum award is actually issued, it could be someone else's problem. The general counsel may have moved on. That's especially true of states and state entities where there's very frequent turnover. In my personal experience, while it's very common for jurisdiction to be bifurcated from the merits, far less common for quantum to be bifurcated into a separate phase, at least at the very beginning of the case. I've only seen, in 23 years of practice, 3 times have I had a case where there was a separate quantum phase. And only 2 of those did the arbitrators issue the first procedural order in the case at the very beginning, before they knew much about the case beyond the request for arbitration, where they decided to have a separate quantum phase down the road if we got past jurisdiction liability. The third case where it happened occurred not because the parties requested it, but because the tribunal, after hearing the full case, including damages, issued on its own a decision on liability and said, we want you all to come back and argue quantum separately. And so we brought all the quantum experts back for a second time, 3 years after the initial hearing in that case. Now, I think the infrequency of bifurcation, again, is driven generally by claimants' unwillingness to ask for it or to resist it when either the respondent requested or the tribunal asked the claimant to consider it. So my focus here is on why I think and why I've come to believe that it can be a mistake for a claimant not to consider bifurcating quantum, and how it may even be beneficial for the claimant to bifurcate quantum in certain cases. And I think good counsel should be thinking about these facts in advising their clients who are claimants to consider it. And I can think of 4 situations. The first one is for efficiency if there really is a major pre-quantum roadblock to the claimant's case. Now, as I said several times, claimants are generally loath to do this. They don't want to acknowledge that there's any weakness in their case. And if they concede up front that there should be some issue decided on a preliminary way that could dispose of the case, then that is a sign of weakness. That's the concern that claimants have. But suppose there really is a threshold issue that the claimant, if it's being honest with its own case and if it's being advised properly, could lose. It does the claimant no good to incur the expenses of hiring quantum experts who, in my experience, are the most important cost elements in an international arbitration, aside, of course, from the lawyers, who are always the most expensive. But if there's a genuine chance the case may never get to the quantum stage. And I'll tell a quick war story on this. We had a case several years ago where we represented an Egyptian national who was granted a concession to build a resort development on the Red Sea. And this person grew up in Egypt, spent his whole life in Egypt. In his 20s, he obtained Italian nationality because his mother was Italian. He continued to live in Egypt and eventually was awarded this project, which was expropriated from him by the Egyptian government. And each time the property was given back to him in the Egyptian courts, the Mubarak government just issued another decree taking the property back from him. This went on for several years. He got exasperated and started to look at whether he had international options, and he got an opinion from the person who had written the nationality law in Egypt, who essentially told him that when he acquired his Italian nationality in his 20s, he had failed to take the steps required under Egyptian law to maintain his Egyptian nationality. And so by operation of Egyptian law, according to this Egyptian law expert, he lost his Egyptian nationality and so was only an Italian, even though he continued for many years thereafter to believe he was Egyptian, to be treated like he was an Egyptian by the Egyptian authorities, to use his Egyptian passport, to obtain all the benefits of Egyptian citizenship. So we brought an arbitration on his behalf under a treaty between Italy and Egypt, using his Italian nationality and relying on the fact that he lost his Egyptian nationality. It was a very technical argument. We knew we had a good case on liability and damages, but we had to get over this jurisdictional issue, and we convinced the client to do that first before he incurred all the expenses of quantifying his damages. And luckily, 2 out of the 3 tribunal members accepted that he in fact had lost his Egyptian nationality and could proceed to sue Egypt as an Italian national, and ultimately won the case and won a significant damages award. So that's one instance where I think a claimant should consider bifurcation A second is when the scope of the liability finding may well affect the quantum analysis. And to give another example, we had a case where the claimant's oil field property in Ecuador was expropriated. Also relevant in that case was a tax on windfall oil profits that was imposed by the government at both 50% and later 99%. There were also arguments about whether the government had failed to negotiate an extension of the concession in good faith before the property was expropriated. So all of these issues, the data valuation could have an extreme impact on the quantum, depending on the oil price, and depending on whether this tax needed to be taken into account at 50%, 99%, or not at all, how that tax would affect the but-for production of oil, how many barrels would the claimant have wanted to produce, how many wells would it have drilled. So all those factors had to be, would come into play in the liability decision and would also affect the quantum. Now, sure, the experts could have attempted to build a damages model that was flexible enough to deal with all those contingencies, but that's difficult, that's expensive, and at the end of the day, it just might make more sense in a complicated case like that to hear liability first, let the tribunal issue its decision, and then have the quantum experts model the damages in light of the specific liability findings that the tribunal has made. The third example when I think a claimant should consider bifurcating quantum is when a decision on liability may cause the case to settle. And there would be no need for and again, telling a quick war story on that front, we had a recent case against a government in Southeast Asia where the key question on liability was whether the form of investments that our client had undertaken was legal. He had invested in this country through family members, through proxies, dummy investors. And the host state was adamant that that was an illegal form of investment. And the case was very sensitive because there were probably thousands of other overseas people from this country who had invested in a similar way. And the country did not want to see a decision by an international tribunal saying that this was a legal way to invest. So the whole case was heard together. We won on liability. The tribunal rejected the argument that the form of investment was illegal, but in the end awarded nice damages, but not as much as the client had hoped for. And I think in retrospect, in that case, if we had bifurcated quantum, gotten the decision on liability that was very bad for the state, then the state may have ultimately settled that case for more than what the arbitrators actually awarded. And the final example is when the claimant's quantum case may generally be better served by a hearing devoted exclusively to quantum. We all know how a typical hearing that's devoted to all issues at once tends to go. Sophie mentioned this earlier. There's a few minutes of the opening devoted to quantum. You hear all the fact witnesses from both sides, all of the non-quantum experts from both sides. Then finally, at the very end of the hearing, you hear the quantum experts. Now, by then, the arbitrators have heard a lot of the evidence over many days. They're anxious to wrap things up. The calendar may have been squeezed a little bit, so there's not enough time left for the quantum experts. So what's arguably the most important part of the case may be getting shortchanged. By contrast, a separate hearing that's devoted exclusively to quantum gives the parties an opportunity to present a full and compelling quantum case to the arbitrators. They'll have a fresh set of eyes. They're focused just on quantum. And frankly, a final award that's devoted exclusively to quantum also gives the arbitrators an opportunity to consider all the quantum-related issues in a manner that may not occur when quantum is decided together with liability or also jurisdiction. And I'd encourage anyone interested in quantum issues to read the recent award in the case of Tethyan Copper Company Limited versus Pakistan. Involved an expropriated copper mine where the claimant was awarded $7 billion after a separate quantum phase that followed the decision on liability. And the tribunal's final award, dealing exclusively with liability, is 620 pages long. It's an extremely detailed, some might say excruciatingly detailed, discussion of the quantum issues, but query whether the tribunal would have devoted that type of attention to quantum if it was lumped together with all the other issues in the case. Now, just very quickly, I'll wrap up by talking about one final procedural aspect, and that concerns if quantum is bifurcated, what should the procedure look like? Should it be the same as if quantum is just part of the regular case, where we typically have 2 memorials from both sides? Is that enough? Maybe there should only be 1. Should there be a document production phase as part of the quantum case? Including all those steps is likely to make the quantum phase a very lengthy process, adding to the overall length of the case. But I think those questions are best deferred until after the decision on liability is reached. At that point, the claimants can be fully educated. It may well be quite content at that point, knowing it has a decision on liability in hand, to take as much time as is needed for the quantum evidence to be fully developed, as we saw in the Pakistan case. On the other hand, the claimant may feel that 1 round of memorials is sufficient, and the respondent can't really prevent that since it has the last say. So I would say the procedure in a bifurcated case will be a case-by-case inquiry. So I'll just conclude by saying it's evident that quantum has an important role to play in laying out the appropriate procedure for international arbitration. And bifurcation of quantum from liability is, in my view, an underutilized tool that parties, but particularly claimants, should give greater consideration to, given its potential benefits. Happy to take questions later. Thank you all.
Thank you very much, Craig. الآن أعطي المجال للدكتور مهندس نبيل عباس فليتفضل. Thank you for keeping your promise and sticking to your time.
السلام عليكم. الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه من والاه. راح أبدأ بقصة توضح الموضوع أكثر من الشرائح اللي راح أشرح فيها. موضوع الكوانتم أو التقييم الكم الذي يستحقه المطالب، هذه بشكل عام في 100% أو 99% من الحالات هي مطالبات يتقدم بها المقاول ضد المالك في غالب الغالب. الآن كم يستحق المقاول نتيجة أشياء مختلفة وأشياء كثيرة، هذا هو محور هذا الموضوع. لم أرى إلى الآن يعني مجهود كبير من المهندسين في البحث في هذا الموضوع وتعلمه ومحاولة نشره، وأعتقد أنه أغلب الذين يعملون في التحكيم هنا في المملكة ليسوا على اطلاع كامل بهذا الموضوع. هو طبعا موضوع أغلبه هندسي، لكن يجب أن يكونوا مطلعين عليه حتى يستطيعوا تقييم المطالبات من الطرفين. قبل عدة سنوات طلبت مني المحكمة أني أكتب تقرير في مطالبات مقاول قبل مالك لأحد الفنادق اللي كانت تبنى في المدينتين المقدستين، واحدة منهما. وفي نص المشروع طلبت الدولة إخلاء المنطقة لأنها ستوسع الحرم، فبالتالي توقف المقاول وطلب من المالك أن يدفع له مستحقاته، فرفض المالك على أساس أنه أنا قد دفعت لك ما نفذته أنت. لكن المقاول تقدم بأشياء كثيرة جدا، مطالبات وكانت مرتبة بشكل جيد، وهذا نادر جدا مما وجدته في المطالبات هنا في السعودية. مثلا المالك قال له أنا راح أدفع لك أنت نفذته هنا في الموضوع. قال له طيب أنا في سنغافورة تعاقدت عدة ملايين على المصاعد الكهربائية. قال له ما دام ما جات هنا أنا ما لي علاقة بها. طيب والدرج الكهربائي في هونغ كونغ؟ قال له أنا ليس لي أي علاقة به. طيب أنا اشتريت مبنى صغير جنب الأرض وأزلته لأنه كان قابل للهدم، كان قابل للانهيار، وأنا ما عملت إلا 25% فقط من المشروع. لو كان أنا كملت المشروع كنت أستطيع أن أتحمل هذه التكلفة، لكن الآن بربع فقط المشروع، وهكذا وهكذا. وكان رسل إلى ألمانيا يعملوا له خرائط مفصلة وكذا، لم يستخدم منها إلا الربع. فإذا دون الدخول في تفاصيل ما تم بعد ذلك، لكن هو من حقوق طبعا المقاول أن يأخذ ما تكبده بحسن نية في سبيل تنفيذ هذا العقد. موضوع التغييرات هو أكبر الموضوعات المأخوذة في الاعتبار في موضوع حسابات الكم أو حسابات القيمة في سياق التشييد. التغييرات يترتب عليها مطالبات، والمطالبات هذه قد يكون مختلف عليها بين الطرفين، ولذلك محتاجة خبير في الكوانتم حتى يتكلم عن هذا الموضوع. حساب الكم ليس عملية عشوائية، لكنه يخضع لأحكام العقد أو القانون المعمول به، وليس فقط في العقد. هناك شيء مهم جدا، أنه قبل ما يطالب أي طرف للطرف الآخر عليه أن يخفف من المخاطر، اسمه mitigation of losses. مثلا لو كان عنده 1000 عامل في الموقع وتوقف لسبب ما، بعد شهر يروح يطالب المالك بال1000 عامل مرتباتهم لمدة شهر. هذا غير صحيح. يجب أن يحاول أن يخفض من الضرر عليه الذي سيطالب به الجهة الأخرى. موضوع نقل المخاطر أيضا، وهذا موضوع خاص بالعقود. الجانب الأقوى في المساومة هو الجانب الذي يخفف عن كاهله المخاطر ويضعها على كاهل الطرف الآخر. وفي هذه الحالة هنا في السعودية طبعا الطرف الضعيف هو المقاول في غالب الغالب. عندنا بعض الموضوعات نحتاج ان احنا نتكلم عنها في موضوع حساب الكم او الكوانتم. لازم نتأكد من قواعد التقييم. ما هي القواعد التي قام عليها تقييم أحد الأطراف؟ المماثلة، العمل المشابه، المماثل. ما هي هذه المماثلة؟ كيف نعرفها؟ معدلات جداول الكميات كأساس. المعقولية، ما هي المعقولية في صناعة التشييد وفي المطالبات؟ التكلفة والتقييم العادل. ما هو التقييم العادل؟ يعني تقييم شخص محترف للوضع الحالي الذي وضع فيه المقاول. على فكرة بحث في اللغة العربية اكتشفت أنه المقاول هي بالفتح، هي المقاول أساسا وليس المقاول على أي حال، لكن خطأ شائع خير من صحيح مهجور. يتكلم عن الخسارة والنفقات، موضوع النفقات والربح. الإثبات، ما هي أوجه الإثبات، ما هي طرق الإثبات وكذا. الموضوع الثاني يتكلم عن الخسائر والأضرار ورسوم التمويل، حساب القيمة، المسببات. ما هي المسببات؟ دحين أنا أعطيكم هنا خلال 10 دقائق موضوع يدرس لمدة سنة أو أكثر في الجامعات. واجب تخفيض الضرر والسوابق القضائية المعمول بها. أنا أخذت سوابق قضائية هنا من بريطانيا، وذلك لأنها متوفرة جدا، ولأنه موضوع الكم الكوانتم بحث بشكل كبير في المحاكم البريطانية. هل كان العمل الجديد مماثلا للعمل القديم ولا لا؟ ما هو التقييم العادل؟ المقاول عليه أن يحتفظ بسجلات التكاليف وتكاليف التأخير. تكاليف التأخير هي إيش؟ ما تكبده المقاول بسبب فعل من الطرف الثاني اللي هو المالك أو الاستشاري، وهما فريق واحد، فتكبد به تأخيرا، مثلا تأخر في اعتماد المواد، تأخر في إعطاء الرسومات، تأخر في أشياء معينة، وهكذا وهكذا وهكذا. عندنا مطالبات اسمها مطالبات التأخير، مطالبات التعطيل، مطالبات التعجيل acceleration، وفقدان الإنتاجية loss of productivity. أي مدعي لازم يربط بين هذه الحقائق الموجودة ويقدم اقتراح بقدر ما هو ممكن، لأنه لا يستطيع أي شخص أن يحسب إلى آخر ريال في حساباته، ولكن يحسب بقدر الممكن عمليا، وهذا ما يستطيع المحكمون الحكم عليه، هل هو كان بشكل معقول ولا لم يكن بشكل معقول. طيب، احيانا نطلب تقييم بند من البنود التغييريه بسعر مختلف عن اللي موجود في العقد، لانه الظروف التي تمت فيه لم تكن مماثله للعمل في العقد، او ان العمل نفسه ليس مماثلا، فبالتالي سيكون هناك اسعار جديده، ويحتاج من الخبير ان يحدد ما هي هذه الاسعار الجديده. موضوع المعقول والمعقوليه، يعني بيقولوا تفسر شروط العقد كما لو أن شخص مناسب عنده كل المعرفة الأساسية التي كانت متاحة للأطراف، فهم لغة العقد وفسرها على هذا الأساس. إذن هذا هو المعقول أو المعقولية. التقييم العادل مبني على أنه ما كان يتكبده المقاول بشكل معقول وسليم في حالة أنه العمل استمر. نرجع لفكرة الفندق اللي جنب الحرم، أنه الرجل راح بحسن نية وتعاقد على أشياء خارج البلد، المفروض أن هذه الأشياء بحسن النية تعطى له ما دام ما عملها تعسفا. أحد التعريفات يجب أن تكون قد تكبدها المدعي بالضرورة وبطريقة معقولة، يعني ما كان لا يمكن كان تجنبها بأي طريقة بواسطة مقاول خبير. المشكلة أنه المقاولين غير الخبراء يقعوا في مشاكل كبيرة جدا، ثم يأتوا للمالك يطلبوا التعويض. يجب أن يكون التعويض مطلوبا من مقاول خبير لا يقع في المشاكل السخيفة. موضوع عبء الإثبات يجب على الجهة المطالبة أن تؤكد للمحكمة أو لهيئة التحكيم أن عبء الإثبات عليها، وتدرك المحكمة أن هناك هامش خطأ مقبول. تكلمت أنه لا يمكن أنك أنت تجيب حساباتك إلى آخر ريال. أنا شفت ناس كثير من المقاولين اللي حصل لهم خسائر، عشان يثبت للمحكمة يروح لحاسب قانوني يشوف دفاتره ويقدم بها تقرير. طبعا هذا طريقة خاطئة، المفروض تروح لخبير هندسي فاهم في الموضوع هو الذي يتقدم لك بالمطالبة. بعض الحالات حتى المحاكم في بريطانيا كانت تأخذ على مبدأ الاحتمالات، يعني إذا لم يكن موجود دليل مفصل قاطع فيمكن أن تبني على هذا المبدأ. المفروض أن المدعي يساعد نفسه في تقديمها مكتملة وصحيحة، ويجب أن يساعد المحكمة في استقبال هذا العمل. طيب، هنا كلمات كثيرة ستتردد على مسمعك: كلمة التأخير، كلمة الإرباك disruption، أو التسارع acceleration، أو فقدان الإنتاجية loss of productivity، أو أي تأثير آخر. هذه كلمات كلها يجب أن يكون الخبير الذي يتقدم بالمطالبة على علم بها، ما هو التأخير وما هو الإرباك وما هو التسارع وفقدان الإنتاجية وخلافه. إثبات الضرر، طبعا المدعي هو الذي عليه إثبات الضرر. ما هي الأضرار التي يتعرض لها المقاول؟ بشكل أساسي ما عنده إلا إما تكاليف مباشرة أو تكاليف غير مباشرة. التكاليف المباشرة هي التي توضع في المشروع بذاته، أما التكاليف غير المباشرة فهي النفقات العامة وما يرتبط بموضوع التأخير، مثل مصاريف الموقع ومصاريف المركز الرئيسي. بعض الناس يعني يتجاهل موضوع مصاريف الموقع. في مشروع متوسط ممكن مصاريف الموقع تكون 10,000 ريال في اليوم، لكن في مشروعات عملاقة ممكن يصل إلى 1,000,000 ريال في اليوم. فأنت يا مالك لو أخرت المقاول 5 أيام فأنت كبدته 5 ملايين ريال مصاريف في الموقع. طيب
دكتور نبيل هستأذنك، أنا آسف للمقاطعة، لو كلمة الختام لأن احنا ناقص لنا دقيقة. شكرا.
طيب في طرق كثيرة لدراسة هذا موضوع الإرباك وعدم الكفاءة وفقدان الإنتاجية مذكورة هنا، منها الميجرد مايل تكنيك، قياس الميل، ودراسات صناعة التشييد. عندنا تحليل بين المخطط له مقابل المنفذ الفعلي بالنسبة للوقت وبالنسبة للتكاليف. المقاول كان يتوقع أنه ينفذ ب100 مليون، نفذ ب130، معناته في مشكلة، لكن لا تؤخذ كده على عواهنها. في التوتال كوست وفي الموديفايد توتال كوست. طيب يجب أيضا أن يضمن الخبير منهجيته كيف وصل إلى هذه الحسابات. عندنا ظروف تؤثر على الموضوع الكمي، وهي تغييرات صاحب العمل وتدخله. احنا عندنا في منطقة الشرق الأوسط تدخلات صاحب العمل كثيرة جدا جدا، مما يسبب إرباك هائل خصوصا للمقاول الذي يأتي من خارج المنطقة، يعني لا يعتقد أنه هناك تدخلات بهذا الدرجة من الملاك. أهم شيء الوضوح والدليل والدعم في موضوع الخبرة. طيب الخلاصة أنه أي عمل يقدم لابد أن يكون مدروسا، لأنه بنفترض في أعضاء التحكيم الخبرة الكافية لتقييم هذه المطالبات، ويجب على كل طرف أن يقدم الأدلة الكافية والموثوقة ذات الصلة، ويجب أن يأخذ في الاعتبار احتياجات المحكمين من فهمهم ومن منطقهم ومن كذا وكذا وكذا. أشكركم جميعا، السلام عليكم ورحمة الله.
شكرا جزيلا دكتور نبيل، وأعطي الآن الكلمة لبيور، فليتفضل. هيكون آخر موضوع من موضوعات هذه الجلسة، ثم ننتقل لحضراتكم. احنا عارف ان احنا أخذنا جلستين ورا بعض، هيبقى في وقت إن شاء الله لبعض الأسئلة.
Your Excellencies, ladies and gentlemen, good morning. Assalamu alaikum. Let me start by thanking the organizers for inviting me to speak today. It has been a great honor and an immense pleasure to be here with you today. And also let me thank or congratulate the organizer for putting on such a magnificent event. Now, I've been asked to talk about a topic, punitive damages in international arbitration. When I was first introduced or asked to talk about punitive damages, I thought, well, it's actually quite a bit left field. And reflecting on my practice, which is now nearly 20 years as arbitrator in counsel, I haven't come across many cases where punitive damages was actually an issue or was awarded. And I assume the same applies to many of you, especially as punitive damages is a topic that is not very present in this part of the world, and in fact, not in many other parts of the world. So what I thought I do, given that we only have 15 minutes, is to do a very basic introduction to punitive damages, dealing with the issues about what is punitive damages, most importantly, how is it treated in the national laws, and to what context and what extent is it applied in international arbitration. And most importantly, and that's actually the first point I would like to start with, is the terminology we use. And when Dr. Mohammed introduced the topic at the very beginning, and I listened to the Arabic translation, I realized there's already a problem with translating the term of punitive damages into Arabic and from Arabic back into English. And similar issues also exist in the terminology used in the English language. And when I talk about punitive damages, there are different terminologies that are used. One example is exemplary damages, or an American concept is also treble damages, where it's a predetermined amount for punitive damages. However, and this is a very important point, punitive damages is not to be confused with moral damages or aggravated damages, but I'll get to that point shortly and briefly discuss the differences. So let's start with a very basic definition of punitive damages. And one leading authority, and I quote, defines punitive damages are sums awarded apart from and often in addition to compensatory or nominal damages, usually because of particularly aggravated misconduct on the part of the defendant. So that's a very good definition. And what does it tell us? First of all, punitive damages are non-compensatory in that they do not restitute a particular damage suffered by the defendant. And that is although the damage is usually paid to the claimant. And most importantly also, as the name already suggests, punitive damages are punitive in nature. That means there are a penalty rather than damages. And that actually makes punitive damages, the terminology, already very confusing because it is not a damage in its original sense. Now, the purpose of punitive damages is to deter the defendant and others from engaging in similar conduct. And is often awarded when compensatory damages are deemed inadequate or involving particularly aggravated conduct. So that's pretty much the basics about what punitive damages are. And I said at the very beginning, they're not to be confused with moral damages. And just to give you a brief overview of what moral damages are. Moral damages are compensatory in nature, and that's the main difference to punitive damages. And the purpose is to compensate physical persons' emotional distress or severe pain and suffering. And that's actually one of the problems why moral damages are not used widely in commercial disputes, because in commercial disputes we very often have legal entities who do not suffer pain. They might suffer monetary pain, but they don't suffer physical pain, and therefore compensation for physical harm can only be compensated to natural persons. So let's turn to the first subtopic of punitive damages and how they're treated and dealt with under the national laws and the legal systems. Now, as most of you might be aware, punitive damages have been well settled in common law for many, many centuries and are still a significant feature of tort law in many common law jurisdictions, including, and that's not an exhaustive list, Australia, Canada, England, New Zealand, Northern Ireland, Ireland. Now, I mentioned one particular point just now. They are very well settled principle in tort law, not necessarily in contract law. But most of you will be aware of punitive damages in the context of the United States, and that's actually where the homeland of punitive damages is, and also where the concept of punitive damages is most widely applied, not only in tort but also in contract law. Now, if we take a broader look globally, and especially in civil law jurisdictions, the concept of punitive damages is much less common. And to take the EU countries as an example, the concept of damages is still one of compensation. And for that reason, punitive damages, which we established at the very beginning, is a non-compensatory type of damages, doesn't really exist. And there are many laws in the EU, the French Civil Code, the EGBGB, which is the introduction law for the Civil Code in Germany, have provisions that expressly state so. And there's a famous decision from the French Court of Appeal in Paris from July 2006, stating expressly the principle that the gravity of a fault, that is in tort, does not affect the amount of damages to be awarded to the victim. And again, that judgment confirms the lack of punitive elements in damages in those civil law jurisdictions. More importantly even, is that the concept of punitive damages in many of the civil law jurisdictions is considered against public policies. There are some very few civil law jurisdictions which I came across during my research for this presentation that have, and I wouldn't call it a punitive damages remedy in a system, but something that is not too dissimilar. And those nations include Norway, Poland, Brazil, and also the Philippines. There's also one exception, and that is Spain. Anyone from Spain here? No? In Spain, there is a Supreme Court decision from 2001 which held that punitive damages awards are not contrary to Spanish public policy. And that is the exemption rather than the rule for most of those civil law jurisdictions I just mentioned. Now, this could actually end the presentation already when I say there's nothing in the civil law jurisdictions that actually addresses the punitive damages. But there has been some movement recently, very recently in fact, to revise the historic approach of punitive damages in those jurisdictions. And on the forefront of that development is France. There has been a landmark decision in 2010 by the French Supreme Court who reversed its position towards enforcement of foreign punitive damages awards in a judgment, and I quote again, "Punitive damages are not contrary to French public policy as long as they are not disproportionate to the damage caused to the plaintiffs by the breach of a contract." Now, that is quite a remarkable change because, as we heard earlier, under French law, initially, until the early 2000s, punitive damages were against public policy. But France goes even a bit further, and there have been a few years ago discussions about a reform of the French Civil Procedure Code to include punitive damages for circumstances where the defendant's fault is manifestly premeditated and particularly where those actions were primarily driven by monetary gain. Now, again, I did some research to see before the presentation here whether there's any update on those laws. I couldn't find anything, but maybe there's some French practitioners amongst you who have any further information. We might discuss those in the question and answer session afterwards. Now, there's also been some criticism about some of those civil law countries' approach towards refusing to enforce punitive damages awards on the basis of public policy. And that criticism is based on the wording of the public policy exclusion under the New York Convention. And the criticism is that those jurisdictions apply the public policy exemptions on the basis of their domestic public policy, whereas it should, and that's up for debate as well, it should be an international public policy that applies here. So there's been a lot of discussion, a lot of debate, and the potential for some movement on those issues. So what does it mean, this whole discussion about punitive damages in civil law jurisdictions? As I said, at least in some civil law jurisdictions, the position on punitive damages being against public policy may no longer be sustainable in the stricter sense, and there's arguably a change of mind and awareness towards public damages or punitive damages. It doesn't, however, mean that even if all these reforms I just mentioned, that punitive damages are soon going to be the norm and something which arbitrators use on a regular basis. Most of these discussions that I just mentioned are purely in relation to the public policy exemption and therefore relevant for the enforcement. Now, let's get to the main point of the presentation, that is punitive damages in international arbitration. Now, as I mentioned to you at the very beginning, there's a very practical application in the context of international arbitration. And there are two main reasons for that. The first one is because punitive damages is or has a very limited availability under national laws, often against public policy, and where punitive damages are against public policy, the arbitrator simply cannot award punitive damages. And the second limitation is the limitations of the enforcement of punitive damages awards in various jurisdictions, again limited by the public policy, where the courts refuse enforcement of punitive damages awards on the basis of the New York Convention exemption for awards being against the public policy. That is mainly the civil law world. Now let's move to the homeland of punitive damages, which is the United States. Now, even in the United States, the concept of punitive damages to be awarded by tribunals is uncontested and without question. And the traditional view is that punitive damages are considered the exclusive resort of the courts and should not be available to arbitral tribunals. Now, that is the historic position in the United States. And the leading case on that matter is the Supreme Court of New York State case of Garrity versus Lyle Stewart of 1976, where the court, and I quote again, said, "Permitting an arbitrator to award punitive damages violates public policy, inter alia, because the power to punish constitutes a monopoly of the state. And further, an arbitrator has no power to award punitive damages even if agreed upon by the parties." That is, even if the parties in the arbitration clause say so specifically that the arbitrator shall have power to award punitive damages, that doesn't mean, under the historic concept, that the tribunal in fact has the authority to do so. Now, there has been some development since, and the first decision of the US Supreme Court in 1985, it's a case by the name of Mitsubishi Motors Corporation versus Solar Chrysler Plymouth, opened up the awarding or the availability of punitive damages for tribunals for antitrust matters. And shortly after, in 1987, the same court also said that punitive damages shall be open for tribunals in RICO claims. Now, RICO claims, for those of you who don't know, is the Racketeers, Influence and Corrupt Organization Act, which deals with the proceeds of crime. And it was not until 1995 that the Supreme Court finally affirmed the general power. Before that, with those decisions, it was still limited to cases with a public interest, that arbitrators have the general power to award punitive damages in Mastrobuono versus Shearson, Lehman, Hutton, 1995. And that case is still the authority on the issue of tribunals' authority towards punitive damages. Now, this is all good. We have, at least in the US, broad powers for tribunals to award punitive damages. But if you look at the empirical data, there's actually not much in terms of arbitral awards reported that include punitive damages. I looked through the ICC reports, didn't find any reported ICC cases awarding punitive damages. There are very few maritime arbitration cases. There are two decisions, one from a German court in 1992 and one from an Italian court in 2007, that deal with punitive damages award, but refusing to enforce it because of the public policy grounds I mentioned earlier. And therefore, it still remains largely a very American phenomenon. And that's due to the reasons I just mentioned earlier, the limited availability of punitive damages under the national laws, the public policy issues which prevent enforcement in many jurisdictions, and third, actually, arbitrators' awareness about punitive damages. Now, what are the practical considerations in the context of punitive damages? Well, most important is the question, what law do I apply on the question whether punitive damages apply or not? The majority view is that the lex causa, which is the substantive law of the contract, is relevant. Others say, mainly from the US, it's the procedural law. If you ask me personally, I actually have to agree with the procedural law proposal, because if the argument is that punitive damages are not actually damages, they're not compensatory, and they're in fact a penalty, then that penalty, in my view, must be dealt with under the concept of what the procedural law or which procedural law applies. The same situation is with arbitral laws and rules. Arbitral laws are generally silent. I couldn't find anything on my research. There's nothing in the arbitration law. There's nothing in the relevant national arbitration laws I could see. And the same applies to the arbitration rules. Again, nothing in the ICC rules, LCA rules, the SCCA rules. There are two exceptions. Two exemptions where punitive damages are mentioned. One of them is the ICDR rules in Article 31.5 and also the ARIAS rules, which are the insurance and reinsurance rules of the Arbitration Society in the UK. But those rules specifically state arbitrators they have no power to award punitive damages unless specifically authorized to do so by the parties. I'm going to wrap up because we're running out of time. Maybe just a few things at the very end on the conclusion, and that is what the parties and the arbitrator should be aware of before awarding punitive damages. For the arbitral tribunal, it's mainly important that the arbitrator delivers an enforceable award, and therefore it's essential for the arbitrator to look at the public policy issues in the country or at the seat jurisdiction, and also for the country of the lex causae, that is, which substantive law applies. And he should be careful, even if he finds a law that generally allows punitive damages, mainly common law jurisdictions. Many common law jurisdictions limit the application of punitive damages to matters of tort, but exclude it for contractual disputes. And the same applies for the parties. What do the parties need to consider if they want to apply punitive damages? Well, first of all, again, choose the procedural law and the substantive law from a jurisdiction which recognizes punitive damages. Consider where the award needs to be enforced, because it's all good and nice if you have an award with punitive damages which was authorized under the law of the seat, but you can't enforce it in any jurisdiction. And then I think most importantly, choose an arbitrator who comes from a jurisdiction that actually deals with punitive damages and who has experience in punitive damages. If you comply with those principles, then you might have a chance to get an enforceable award, including punitive damages. I realize we're out of time, so that concludes my presentation. Thanks for listening.
Thank you very much, Bjorn.